leader, Nooga Radio, AM 1240 and 92.7 FM.
Good morning, Chattanooga. This is Jim McCoon, and welcome to Legal Bytes, your weekly show discussing, for you, the listener, issues relative to legal interests in your personal lives as well as in your business. And today we have as a guest and co-host Trevor Atchley. Hello, Trevor. How are you?
Hey, Jim. I'm doing fine. Thank you for having me.
And Trevor, today, and one of the reasons I asked you to come on today is because I want to discuss something that I've had a couple of clients talk to me about recently, as well as I've had someone at our church raise an issue with me. And that's with respect to how to help someone who seems to have a disability, but there's no legal right to help them, if you understand what I'm saying. And I'll give you a situation. I've got a friend who has a young adult child who has been absolutely and completely unruly in the home, acting chaotically and sporadically, sometimes withdrawn, sometimes confrontational, seems to be delusional, and in fact has gotten into some criminal issues because of some of their activities. And wanted to know, how can we help them? Because they think that there's something that's not right. These aren't just social actions that are inappropriate, that they think that there's a root or fundamental problem or a cause, perhaps going back even to a prior accident. And so the issue is, how do you help, or can you help someone like that? And even for the attorney who may be representing them criminally, how do you help that attorney put on a picture for the judge or for the jury as to what's going on, and how do you address that?
Those are all good questions. It sounds like, unfortunately, a very difficult situation. There is a legal process whereby the court can remove decision-making authority from an individual, from an adult, and invest that decision-making authority in a court-appointed fiduciary.
And that's exactly kind of what we're needing here, because here, this young adult, I think he understands that he's got and needs help, but he refuses to get help. So how do you force medical or psychological treatment and help to bring these issues to resolution for the family, for the law, for the community?
Well, that as far as compelling treatment, the law is very reluctant to do that. And so it requires an extraordinarily high burden of proof, the highest civil standard, which is called clear and convincing evidence, to show that the individual you're needing to help is a person, quote unquote, with a disability, which means they have some type of cognitive impairment or some physical problem which impairs their cognitive function, and they're not able to make decisions on their own. Once you have established that, and you have to establish that with medical proof, you have to have a doctor opine that the individual is suffering from some type of cognitive impairment or some physical disability.
And how do you do that? What is the procedure that if someone in my neighborhood called, or if I had a client call and they wanted to talk to you, for example, what are they asking about? What is this procedure called?
Well, the legal name is a conservatorship. And so you would file a petition to ask the court to appoint a conservator over the individual. And the conservator can either be over a person's person, that is to make medical decisions for them. The court can appoint the conservator over the property, that is to manage their finances, or the court can appoint the individual over all aspects, both financial and personal decisions.
Now, that sounds like a fairly drastic step.
It is. It's I always advise and counsel clients, this is the last, your decision of last resort. Only do it if it's absolutely necessary. Quite frankly, it's not a very good planning tool. It'd be much better if the individual that you're concerned about had authorized someone to act for them in some type of durable power of attorney, and then the agent was able to help take care of them. Having a court-appointed conservator, it literally is the court removing rights from the individual, investing those rights in the court-appointed fiduciary.
Okay, well, let's talk about that. But a power of attorney, and when we use the word durable in the law, what we're saying is it continues in effect even though the person who appointed the attorney may be incompetent.
That's correct. And
but the durable power of attorney, if you're holding that, say for example, I've got a durable power of attorney over my mother, and my mother is beginning to slip significantly with her cognitive abilities, and I feel like that I need to get her into some treatment. I need to maybe even put her into a home. My power of attorney is not going to authorize me to forcibly do any of that.
No, that's correct. Powers of attorney are by their nature revocable, assuming the person has the legal capacity to revoke it. And the agent only can act with the authority of the principal. So the agent can't force the principal to do something that the principal doesn't want to do.
Right. So my mother could basically say, Jim, you stop right now, and I'm not, leave me alone, or I'm going to revoke your power of attorney and give it to someone else.
That's correct. Or just file a revocation, just revoke it, and not have someone to act on her behalf.
So if you get into a posture where you can't get someone to help themselves, then the conservatorship may be the way to go.
It can. Particularly when we're dealing with psychiatric disorders, it can be extraordinarily difficult to get somebody treated who does not want to be treated. So it's not going to be a panacea. You're not going to get a conservator appointed and that solve all the problems. It's going to be, unfortunately, a very long process of probably extended court proceedings, and then ultimately having to rely on mental health professionals to determine what course of treatment is best, and then authority from the court to order the person to submit involuntarily to treatment.
Okay. So the court does have the power does the court have the power to involuntarily order assessment so you can determine if they need treatment?
Yes. Now that is under the conservatorship statutes. And when you file a petition for conservatorship, I mentioned earlier, you have to have medical proof.
Right.
And so the question always is, well, how do I obtain the medical proof? So normally if, let's say, we're talking about your mother, let's say you're her power of attorney for healthcare, you would have authority to talk to her doctors and ask the physician to give you an opinion as to whether or not she's competent or, has some cognitive impairment, which impairs her ability to make decisions.
But if I don't have the power of attorney and she's not authorized me in her documents to speak with the physicians, I'm blocked by HIPAA to even obtain the information from her healthcare professionals.
That's correct. So in that circumstance, what the law provides is you file a petition for the appointment of a conservator, and you allege in the petition that the respondent, which is what the law names the person you're trying to have a conservator appointed for, respondent refuses to submit to a medical evaluation, and you ask the court to place an order directing the respondent to submit to the medical evaluation.
Okay, so at that point in time, we are getting an involuntary assessment done.
Correct.
And I assume that before that order goes down, that's not something that's done at the beginning of the case. There's a hearing.
That's correct. The court would hold a hearing to determine, make sure that there's a good faith basis for the application, and give the respondent an opportunity to object and come in and say, Your Honor, I don't need this. This is, pretextual or something. They're just my family's trying to get control over my money or something, which, happens occasionally. But the court will make sure there's a good faith basis for the request, and then put down an order directing the respondent to submit to the evaluation.
Okay. So let's assume that a petition for conservatorship is filed, that I don't have medical proof at the time, but I can set forth factually things that I have observed that have caused severe concern. They're abnormal, unreasonable risks to her health or safety. But she refuses to be assessed. And I don't have any authority to require it or even access her medical records. So I filed the petition and put all that in there. Does the court appoint anyone to represent her, my mother, or the respondent, the person we're trying to take action against?
The court can, and that would be what the law calls an attorney ad litem. Normally, the court only appoints an attorney ad litem in two circumstances: whether there's a petition for emergency conservatorship, requests an attorney be appointed. The typical appointment is what's called a guardian ad litem. And a guardian ad litem is an attorney appointed by the court to act as an impartial neutral to investigate the allegations set forth in the petition and then to file a report with the court.
To see if there's really a factual basis for what they're saying. Is it filed in good faith? And to see if, after meeting with the respondent or the person you're trying to get a conservatorship against, to see if they really are acting odd or if there's any concerns in the way they conduct themselves.
That's correct. And the guardian ad litem's initial duty is to ensure we're protecting the rights of the respondent. So literally the very first job the guardian ad litem has is to go out and, as soon as practical after appointment, meet with the respondent in person, explain to them the content of the petition, advise them of their rights under Tennessee law, and then move forward from there, investigating other allegations in the petition.
I guess one of the first questions is do they oppose having a conservator appointed?
That's correct. And whoever in the petition, normally it sets forth who the petitioner wants appointed as conservator. So the guardian ad litem would talk to the person about whether this proposed person, she has any objection to that person serving as a conservator.
Okay, and if so, why? And
correct.
See if there can be reasons given why that would be inappropriate.
Some articulable basis, correct. And these cases run the gambit. Sometimes these petitions are filed for someone who's just been in a severe car accident and is literally lying in bed with a severe traumatic brain injury and needs somebody appointed to manage the property in almost an emergency basis. And that case is sort of straightforward. Obviously, the person can't act on their behalf. But then you have other cases where you have children fighting over care for the parent. And the parent can be questionable, maybe they're advanced in age, but they're still capable of handling their affairs. But the children are fighting over how to manage mama's property. And so one of the children files a petition for conservatorship. In those cases there, you probably have more of a question as to whether or not it's really appropriate for the court to intervene.
Sure. And, because if you appoint anyone as conservator, you've chosen sides.
To a certain extent, correct. I mean, the court maintains control over aspects of the conservatorship, and the conservator has to file a property management plan. And the court has to approve it. So the court retains a lot of authority and control over how the property is supposed to be used. But you're right, though. To some degree, the court's choosing sides.
Okay. So is the court bound to choose who's suggested, or can the court go out and choose an independent conservator?
So the court is supposed to choose whomever the court finds is in the best interest of the respondent. The Tennessee statutory law creates a hierarchy of persons to choose, but the court's not bound to follow the hierarchy if the court determines that it's not in the best interest of the respondent to appoint somebody either that's named in the petition or that's listed in our statutory hierarchy of persons to be appointed.
Okay. So for example, my lead example, when I got into this, we've got a young adult who is acting erratically, irresponsibly, and not simply because of poor upbringing or personality, but because of believed to be psychological issues. In those kind of situations, let's say mother files for conservatorship, but child, either through paranoia or because of family issues, believes that mom's just trying to take control and opposes having mother appointed. How does the hierarchy under the law run for the judge?
So the law provides first to be considered is an agent authorized to act in a durable power of attorney.
Okay.
By the respondent.
So if they've already chosen someone in the past, then the court believes that's probably a good person.
The legislature, correct, believes that the court should first consider that person. If that doesn't exist, then the court, the next in line are sort of what are closest relatives by consanguinity, meaning your heirs at law.
Okay.
So this young man, if he's married, his spouse would be first. If he has adult children, they would be second. And then if there's neither a spouse or adult children, then you would look to the parents, in this case, the mother, If for some reason the mother wasn't a good choice, then you would look to siblings.
Okay. And if none of those, let's say mother can't serve, or there's enough animosity that the court doesn't feel comfortable with mother, and siblings are still minors. At that point in time, where would the court go for the conservator?
Court would probably look to a local member of the bar to serve as conservator, or there's a public guardian that possibly could serve, depending on whether the person has financial resources to afford an attorney to serve as conservator. But typically in those instances, the court appoints a local lawyer to serve.
Okay. And that local lawyer, his job then is to do what as the conservator?
Well, his paramount duty is to protect the best interests of the ward. When a conservator is appointed, the respondent becomes a ward of the court.
Okay.
So you refer to him then as a ward. But it depends on what the order provides, because in the order, the court will specifically state what rights are removed from the ward and given to the conservator. So let's say it's over the person, let's say it's to make medical decisions. Then the conservator's job is to essentially consent or withhold consent to medical treatment for the ward. Now you get into a question in these mental health cases if the individual refuses to submit to treatment. And our chancellor here interprets the statutes to require you to file another petition under the mental health statutes for either emergent or non-emergent involuntary treatment.
Okay. So even though you've already got a conservatorship in place, the conservator doesn't have the authority to enforce his rights through the conservatorship. He's got to file something under the mental health statutes.
That's the way our chancellor here interprets the statutes, correct?
Okay. All right. So I guess the bigger question for me, though, is if we've gone to someone who's totally independent from the family and has no history of knowing what's going on, how can that individual, that independent stranger to this situation, be able to put together a property management plan, be able to put together a health management plan or healthcare management plan, and do anything so how do they get that information, and how much time do they have to report back to the court?
Well, those are good questions. In the petition, the petition is supposed to contain information regarding the person's health, treatment, and financial information.
Sure, but in this situation, you don't have a HIPAA release when the petition was filed. So you don't have medical records or access to medical information because it's all protected. They've refused to go in and be evaluated, so you don't have any current information to establish a disability. And so you've just gotten what the court may have ordered in the course of the conservatorship proceeding.
So during the conservatorship proceeding, a lot of that information would be obtained by the guardian ad litem.
Okay.
Because under our statutes, the guardian ad litem has authority to obtain information from doctors, and the statute specifically provides that the guardian ad litem shall be considered the quote unquote customer when dealing with financial institutions. So the guardian ad litem can go out and obtain all that information.
Okay.
And then provides that information to the court. And then ultimately the court appointed conservator would probably rely heavily on that GAL report in formulating a property management plan and a treatment plan, but would also at some point conduct its own due diligence, determine do its own investigation regarding the merits and what findings were in the report of the guardian ad litem.
Gosh, so right now I'm thinking about the expense for all this, because you've now got the person who filed the petition would have had a lawyer to help them file it and prepare it. You've got a guardian ad litem that the court has appointed that you said is a lawyer whose interests are to, one, look after the best interests or find out the best interests of the potential ward, and at the same time report back to the court and be the court's eyes and ears, basically.
Correct.
You've got a attorney ad litem or an attorney for the potential ward who's contesting the creation of the conservatorship or any things they're trying to do against them. So you've got all these people in this. That's a lot of legal fees being incurred. How is that paid for?
Well, the statute provides that the court has a lot of discretion in how to order payment of those fees. The court can award payment of the petitioner's attorney's fees and the guardian ad litem fees from assets of the ward or assets of the petitioner.
Oh, really? So,
Yes.
so in this situation where you've got a young adult who doesn't have a financial estate of any value, the court could make the petitioning mother pay for all of this?
Yes. The court has authority to do that.
So that's almost punishing her for trying to do the right thing to protect her child.
Well, a lot of these changes in the law came about within the last 5 years, where the legislature became concerned that there was some abuse and financial, people taking advantage of folks financially. Court-appointed conservators actually not doing what was in the best interest of the ward, and basically found that some of these petitions, the law at that time provided that if a conservator was appointed, the court was basically directed to assess all costs against the respondent. But the legislature determined that wasn't really fair, and actually, I think, acted as to encourage the filings, because it was the petitioner sort of was at risk free in filing it. And so the legislature changed the statute, amended the statute, and now provides that the court has more discretion in how to award those costs to be paid.
Okay. But it seems like to me that if the court has determined that a conservatorship should be established, that is, the respondent was disabled, needed the help of the court, and needed to have their rights taken from them and placed in the hands of a independent person to serve as a conservator for them, then mama was right. This was non-abuse. And so why should the petitioner suffer all of the expense of these proceedings?
Well, the statute specifically provides that the court should give deference to the fact of whether or not a conservator is appointed, in considering whether to assess the cost against the respondent or to assess the cost against the petitioner, or to divide the cost between the parties in some way.
Okay. I guess my concern is if mama's the only one with a pot full of money, because the young boy doesn't have anything, then that really exposes mama, despite all the equities and despite the fact she was correct. She's the only one who can pay all the professionals that the courts had appointed in this proceeding.
That's correct. And that's something that the petitioner would need to consider before filing the petition.
Okay. So is that something you advise when clients come in to you about a conservatorship?
Absolutely, yes. And there's actually been a problem here in Hamilton County where the guardian ad litem, the attorneys who have served a guardian ad litem have not been paid. And so the court has proposed modifying our local rule to provide that the attorney has to sign off as a surety, the petitioner's attorney, to file off as a surety on that, making sure all the attorneys' fees get paid.
As court costs?
Correct.
Well, isn't there a limit under the court cost surety to $500, or is this an unlimited surety?
We'd have to look at the rule. I think it, at least on its face, purports to be unlimited surety.
Oh my goodness. So that really makes it more difficult for the attorneys even to represent someone in a conservatorship.
The concern among the conservatorship bar is that local rule could have a chilling effect on filing conservatorship actions, because attorneys are not going to want to incur the potential liability.
Sure. I agree. I couldn't imagine underwriting the whole cost of the case simply because my client was right, but has the funds to pay.
Well, the court has discretion. It's not guaranteed that the court's going to assess all costs against the petitioner, but the court has discretion to do that under our statute.
Okay.
Now,
go ahead.
Well, the attorney ad litem has to be paid by the respondent if one's appointed. So it's one lawyer that the petitioner would not have to pay.
Okay. Well, I see we're at the half hour. We'll see you on the other side, and we'll continue these discussions with respect to how to protect disabled family members when they're adults and not willing to submit to medical or other needs. This is Jim McCoon. We'll talk to you on the other side of the hour.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Cops say Shane Keller and Brittany Renee Ware have both been arrested after the police say they had methamphetamine inside their car, along with needles, pipes, and a handgun. And Miss Ware's autistic son was said to be in the back seat of the car. Cops say they stopped their car because it had a stolen license plate on the back of it. 11 overdoses have been reported in Georgia, and 2 deaths so far. Pills labeled as Percocet may not actually be Percocet sold on the street. It may be something much more powerful. The police are still trying to find out what. The Chattanooga City Council is trying to figure out if some buildings should be no-go zones zones for guns. A Tennessee state House bill has requirements for gun-free zones, which would not be met by the current circumstances for city council meetings. And the first hearing for an ordinance which would suss out where you can use Airbnb begins today. Maps will be created which would zone out where short-term vacation rental services would be allowed and where they won't be. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect lots of sunshine, breezy, and pleasant weather out there through your afternoon. Highs 80 to 82. Tonight, fair, comfortable lows, upper 50s. More clouds will move back in Thursday. Could see a spotty shower or two, but not bad. Highs upper 70s. Lots of sun, lower 80s returning Friday. Do you have a pesky tree that needs to be removed around your home or business? Call Paul Bunyan Tree Service now at 423-421-2104. That's 421-2104. And I'm Machine 12 Chief Meteorologist Patrick Ward on Nooga Radio AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances: business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta, or Greek salad. Jet's Pizza at Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike. Life is short. Eat better pizza.
Let's get Jets. Need a tiller to get things going for the spring? Spiff up your porch, maybe your deck? Come on by and get a pressure washer at Action Rental. Family in town, need some tables and chairs for an event? Come on by and see us. Action Rental. This is Dan at Action Rental on Lee Highway. Come by and see me. Action Rentals.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Welcome back to Legal Bytes. This is Jim McCoon, your host, and with me today as the guest is Trevor Ashley. And if you're with us for the first half hour, we've been talking about how to handle when a family member is disabled, but because of their legal majority, you're not able to force them to do the right thing to try to take care of themselves, either financially or health-wise, or other physical incapacitation. So, you know, that's one of the things we were talking about. And Trevor, you were talking about conservatorships and the methodology for handling conservatorships. For those of you out there listening, if you have questions with respect to how to handle issues in your family where someone's disabled, and again, that can either be a physical disability where they become so ill, but they won't get treatment, or it can be a mental incapacity that it results in a disability. And you'd like to ask a question, you can call us at 423-800-8949 and speak of that. We have a call coming in. Hold on one second, Trevor. Welcome to Legal Bytes. Caller, do you have a question?
I do. I would like to know, you talk about adults and conservatorships. What do you do when it's a minor?
Oh, that's a good question, Trevor. If we've got someone who's a child that needs some sort of help, and either the parent is not able to do it or is not doing it, how do we take care of the child under the law?
Well, there is a legal proceeding for what's called a guardianship in Tennessee, and that is the proceeding to have a fiduciary appointed by the court to manage the person and or property of a minor child.
Okay.
And you don't have the same with a conservatorship. One of the primary issues is, adults are presumed competent. So one of the primary issues, the threshold issue in a conservatorship case, is the medical proof from a doctor saying this adult is not competent to make his own decisions. A child, an infant under 18, doesn't have that presumption because, a child's not legally competent to make their own decisions. So you don't have that initial hurdle. But you do have to have a court-appointed fiduciary, assuming the parents are not able or not around. Biological parents are the natural legal guardians, but if they're not available to act for some reason, then you'd have to have someone appointed by the court to do that.
Okay. Now, I know, for example, when you get into a personal injury action where a minor has been injured severely and there's compensation either through a settlement or as a result of just a insurance policy payment, that a lot of times the various state laws require that you go and get that settlement approved by the court, and the funds may or may not be authorized to go to the parents, may have to go to a separate independent. Is that a guardianship situation you're talking about?
Yes, it is. And there, if the value of the payment to the minor exceeds $20,000, then the law requires there to be a court-appointed fiduciary. But a natural parent, a biological parent, a natural guardian, with court approval, can't accept up to $20,000 on behalf of the child without being appointed by the court.
Okay. Caller, does that answer your questions?
It does. Thank you.
Sure. Thank you so much. Had to work that technical stuff. I'm not very good yet.
Well, I was actually about to compliment you on how effectively you handled all these instruments.
I don't have any of these of this equipment in my law office.
I can't imagine why. It's something you don't have at home.
Going back briefly to this guardianship issue, I know that there's also several issues where parents are not authorized to be guardians. For example, I know if a parent has been convicted and is a felon by law, they're not allowed to serve as a guardian, legal guardian over the child's property.
That's correct. We have a statute that provides that like an ex-convict, someone convicted of a felony who served time in a penitentiary, is legally incompetent to serve as a court-appointed fiduciary.
And the reason why is because they're expected to look over the minor's money, and by being a felon, they're no longer worthy of the trust and honesty, just as a matter of law, despite what kind of person they might truly be.
That's correct.
And so the law no longer gives them that benefit of doubt and doesn't allow them to look over it. Because I know we've had situations where, for example, there was a case several years ago where we had a mother killed in an accident, and the father had served time previously in his life. And there were funds being paid to the child as part of the settlement of the personal injury, the wrongful death action of the mother. And we had to go out and get actually an attorney in town to serve in that role. There's an attorney who does a lot of that in Chattanooga. And so we actually had to have the court appoint him, and he now marshals over the funds when the child needs a computer for school, or if a new bed is needed because the child's grown.
Right.
Those kind of applications I've seen getting filed before the Chancery Court in the guardianship proceedings, where they're trying to get some of these settlement funds that have been invested freed up to pay for the needs of the child.
Absolutely. And that's exactly what that money's for. It's for to provide for the child. And there's sometimes an inherent conflict if a parent wants to serve and the parent says, oh, we need to use this money to buy a new house. Well, that may or may not be in the child's best interest.
Sure.
And so you run into questions of the court having to approve these expenditures. And there can be some friction between the parent and the guardian as to how those funds are used in the best interest of the child.
Well, the bigger conflict I see is the law imposes a duty upon the parent to raise the child and to pay for the child's life needs and support.
That's correct.
That duty already exists. And so the parent suddenly is trying to use the funds of the guardianship to not just supplement what they can't do, but actually replace their financial obligations.
Well, that's exactly correct. Yes.
Yes.
And under that hypothesis,
that's what I've seen time and time again is in the issues in court is, well, is this something that the child truly needs? Answer is yes. Is this something that the parent should be providing naturally as opposed to an extraordinary need that is beyond the budget of the parent that can be paid for out of the guardianship?
That's correct.
Yeah,
that's correct.
And I think it's a lot easier. I know in the example I was given of the young child, he now lives with the grandmother, and the grandmother has no obligation to raise that child under the law, and grandmother's on Medicare and Social Security, and she's able to come in through the guardian, and every time the child has needed something, we've been able to provide it out of the settlement proceeds with the court authority. And it's been because of the fact that these are obligations that she shouldn't have to incur out of her in her golden years. But, she's already taking on the burden of trying to raise the child because her daughter was killed. That's
exactly correct. And a lot of people wouldn't necessarily go through that analysis, but it's absolutely correct that, a parent of a child has a legal duty to support the child through their infancy.
Ask any divorced father with children. He'll find out about that legal duty to support a child.
Yes, I understand that. And the analysis would be very similar there, I think, particularly where you have a parent trying to use the minor's funds to, as you say, not essentially to
replace their
replace their obligation.
Yeah. You're not trying to do something the child needs, and I guess, are there other situations? We've talked about the personal injury minor settlements, but hold on one second. We have a call, Trevor, and we'll get back to that question. Yes, this is Legal Bytes. Caller, do you have a question for Trevor?
I do. I was wondering, what's the difference between a durable power of attorney and a conservatorship, and when is one better than the other? Like, under what circumstances might a power of attorney be better than a conservatorship, or necessary, I guess?
Okay.
That's a good question. They're interrelated. A durable power of attorney is an instrument whereby the principal authorizes someone to act on his or her behalf. And the durable provides that it is effective if the person becomes legally incompetent. And that's sort of an abrogation of the common law that held that if you authorize someone to act for you and you become incompetent, it automatically revokes the authority of the instrument. So now we have durable powers of attorney that remain effective if the principal becomes incompetent or incapacitated for some reason. The power of attorney is, everyone probably needs to have someone authorized to act for them in a power of attorney. And it's common to include that just in a general estate planning package. And that powers of attorney are revocable. So the principal retains the right to revoke the authority granted to the agent. A court-appointed conservator is a court-appointed fiduciary and is only to be used actually to remove rights from an individual and to vest those rights into the court-appointed fiduciary. So it's actually an adversarial proceeding where the rights of the respondent are removed and placed into a court-appointed fiduciary. And it's only appropriate where the person has some type of medical impairment, cognitive impairment, or physical disability, and a doctor opines that the person is in the best interest for them to have a court-appointed fiduciary.
Okay. So then the problem, if all you have is a durable power of attorney, is you don't have the right to compel the principal, the person you're acting for, to do anything, because they're still in control.
Absolutely correct. Yes.
And if you royally tick them off, they're just going to revoke the power, so you have no authority.
Correct.
So, so basically that's where the conservatorship comes in, is to allow you, through the authority of the court, to then continue to act for the best interest of that person, despite the fact that it's against their will or their wishes. Correct?
That's correct. Yes.
Okay. Caller, did I answer your question?
That did. Thank you.
All right. Thank you. That gets to a real interesting issue for me, Trevor, and that is flipping back over to conservatorship. We were talking about guardianship, and I wanted to finish that question I had to you, but that raised an issue. For a conservator, let's say that you've got the conservatorship over the person, so you're responsible for their medical care, and your ward, the person you're supposed to be looking after and taking care of, refuses to take their medications. Let's say it's a mental issue and they really need these medications because they're either schizophrenic or paranoid, and they can actually hurt themselves without the medications, and they're not taking it. How do you enforce your power? You can't physically sit there and put one of those screws between their teeth and open their mouth and drop the pills in. You're not going to be doing that as a conservator, are you?
No.
All right, what do you do?
So ultimately, you would need to get authority from the court to have that person's medication administered by injection. And the court can order that. But our chancellor here, in the context of a conservatorship case, will not compel it. Will not direct a sheriff deputy to go out and pick up the respondent or ward, take them to a mental health center, and then require the medication by injection. Our chancellor here requires the conservator to file a separate action for an emergent or non-emergent involuntary committal proceeding.
Okay, so you no longer are doing that as a conservator. You may have authority to file the action as a conservator, but you're now putting that person back into the authority of the court to determine whether or not they need mental treatment.
Correct, and involuntarily, yes.
Right. So, well, what if it's not a mental issue? Let's say they're not taking their HIV positive, and they're refusing medication for the HIV medicine, and which is going to result in their death if they're not taking their medication. So this isn't a mental issue. This is a true healthcare situation. How can we compel, as a conservator, the person to receive the HIV treatment?
Under our statutes, the authority would imply. The answer is yes, because the conservator has the authority to consent or not to consent to medical treatment. Here would be to consent to the treatment. But when it comes to actually compelling an individual to submit to medical treatment, the enforcement mechanism is sort of where you run into a problem.
That's what I was saying. I could just see all kinds of issues. And then I could see potential exposure to the conservator from family members who said, wait a minute, you took over the office of conservator. You were responsible for my mother's care and well-being. You had a health care plan you were supposed to manage. You had the funds to pay for her treatment, and she's dead because she didn't receive treatment, and it's your fault.
So the conservator there, if I was representing the conservator, if I was acting as conservator, I would file a motion for instructions with the court. And I would ask the chancellor to instruct me on what to do.
Okay. Hold on one second. We've got a call. We'll get back to that. Yes, this is Legal Bytes. Caller, do you have a question?
First of all, I love to hear two of the smartest attorneys in Chattanooga on the air every week. And my second question is, and I hate to admit this, but I think there are times when the court has to step in and make a decision medically. I was in a situation going through a divorce where my daughter needed an operation, and we had a little conflict, and the judge basically said, if you guys don't make a decision, I will.
That happens a lot.
In that case, well, we came to a decision. We came to a conclusion because, we didn't want the court to make it, but, what do you do in that case? I mean, if, I know the grandparents really don't have any legal rights. That's more the parents, but, my question is, when are those we didn't go that far, but when I think our decision was correct, but when are the parental rights severed for anybody out there that maybe is going through a divorce and mom wants one thing done and dad wants the other, whereby the judge will say, okay, now listen, you guys can't make a decision. It's in the best interest of the child. I'll have to make that decision.
Sure. And you're not really severing parental rights in that situation. What you're doing is you have to file a motion to the court to have the court rule on the issue. I'm familiar with a situation several years ago where two parents were in disagreement as to whether a young son should be enrolled in baseball, Little League baseball. And father was very much wanting his child to get involved in the sports and activities, and mother was refusing because mother didn't want to have to be involved and have to take him to practice when dad didn't have visitation. And it actually went to the court, and Justice Barker, when he was on the bench, stepped in and said, look, he said, I don't want to have to make a ruling on this, but I will tell you that I used to be the commissioner of that league. I'm very involved in that league. I know how beneficial it is to children on Signal Mountain. And he said, while I may not make a decision on this point at this juncture, I will consider this issue in determining custody and visitation rights in the future. So the courts can get involved. He persuaded, and in that situation, mother relented and the child was enrolled in the Little League program. But I mean, those issues all the time are rising, whether or not it's that. We get into healthcare issues, just as you were talking about operation. And there you're not really removing a parental right. You're just determining what's in the best interest of children, because two parents.
Yeah, and I think all too often parents are caught up in their own egos.
Right.
And you know, it always has to be about your child. Always. And I think sometimes the parent can't make it about their child because they're busy fighting with their spouse.
Well, Jim, let me comment on this. Under the law, the parents are equal natural guardians. And in the context of a divorce, the parents have already, at least to some degree, relinquished decision-making authority when it comes to child custody to the court, when they've asked the court to intervene and determine a parenting plan and what's in the best interest of the child. So in that case there, the court has inherent authority always to decide what's in the best interest of the child. And when you have two parents, each with equal authority to make decisions, and they don't agree, then the court has no choice but to come in and give a resolution.
Right. If they could agree, they wouldn't be getting a divorce in the first place.
I've never heard it put that way. I really like that. It's almost like entering into a contract, a business contract, where one party backs out or they both back out, and there's still property left. I hate to put kids that way. Somebody's got to intervene. So if you two can't agree to what you promised to agree to for the rest of your lives, then there has to be an intervening party. So in essence, both parties actually forced the court or the judges of the government to be involved by their actions or inactions.
Right. Exactly. And the court cares the most about the children. So we will make sure what the children's interests are paramount.
All right. Thank you so much.
Thank you.
Thank you.
Okay. Bye.
Wow. Okay. Well, that brings us around again to the guardianship issues when we're talking about minor children, how to protect them. Other than the personal injury action, how do we see guardianships come into play here in Hamilton County?
A parent dies and there's life insurance benefits payable to a minor child, and it's in excess of the statutory amount. So either the surviving parent has to apply to be appointed court-appointed guardian, or you have a third party come in to serve to take control of the funds. That happens fairly frequently. You have instances where
does that include a situation where a minor child is a beneficiary under a will?
It can, yes.
So you actually have to have a guardian appointed to receive the benefit of a will.
If it's not directed to a trust, yes. And the child's supposed to receive it outright and it exceeds $20,000, yes, you'd have to have a guardian appointed.
Would that be under the Uniform Gift to Minors Act, kind of a transfer? Would that be treated that way?
Not unless it's provided for it to be.
Okay. Well, we've come to the conclusion of our show today. Trevor, thank you so much for joining us. That was Trevor Atchley with McCoon Williams. This is Jim McCoon, and I thank each of you for listening to our segment today, and we'll talk to you next Wednesday.